Welcome to Legally Speaking, with me, Tarun Nangia. Today, we're going to discuss the important issue that if India has to be a $5 trillion economy, then how its commercial court should be. Or for that matter, any country that aspires to be an economic superpower. Currently, we are about $2.7, $2.8 trillion. So if we have to be about $10 trillion in future, 5 will become 10 given the kind of demography we have. If the court system doesn't keep up, is it even possible for India to achieve those sums? When investors from across the world are looking at quicker dispute resolution, they don't want to go bankrupt either litigating or arbitrating, because that's an important aspect, that people look at dispute resolution as a service, because it is not a criminal violation, it is a disagreement between partners. We will discuss all of that today. I have a very good panel with me. May I welcome Justice Rajiv Sahai and Law. Sir, good to see you again. I have with me Advocate Abhimanyu Bhandari. Good to see you again, Mr. Bhandari, and looking forward to some interesting interventions from you. I have with me Advocate Udit Gupta. He's managing partner of law firm Udit Kishan and Associates. Mr. Gupta, welcome on Legally Speaking, and looking forward to some good inputs from you. So may I first request Advocate Abhimanyu Bhandari to, from the business's end, if he could lay out the fears in the minds of businesses, say, for example, a business out of London, which is looking to invest in India and looks at our court system from the commercial court's point of view, or a business in some other capital, and then we move ahead. Mr. Bhandari.
Yes. Thank you, Tarun. Tarun, when a foreign investor is looking to invest in India, I think one of the first concerns they have, that if there is a breach of contract in their agreement, how quickly they will be able to resolve that issue, how quickly that dispute can get resolved. Now, it is in that context, an investor always looks at in a country where he's investing. But this has always been the case. What has changed a lot in our country now is that we have a new IBC code, as you know, the bankruptcy code. So companies can be put into insolvency and bankruptcy very quickly by an operational creditor or by a financial creditor. Now, if that company is unable to recover his monies from, let's say, a consideration that is due to him from someone else, because it takes him a lot of time to resolve his dispute, whether it's in a commercial court or by way of arbitration, then there is a mismatch of cash flow. And a lot of companies can then trigger into insolvency. For example, take the example of these road construction companies. Large number of road construction companies are struggling to recover their dues from, let's say, various state corporations, NHAI, various other state entities where they've done the work, but they're not getting paid. On the other hand, because they're not getting paid, they're unable to pay their operational creditors. They're unable to pay their financial creditors, and they're being driven into insolvency. So I think from that perspective, foreign investors become very wary, because they want to invest if both ends can be handled. So we've achieved a huge milestone by doing the IBC and taking that to a different level. Our Commercial Courts Act and the whole commercial courts framework that we've got in our country is also very good, but there are lots of issues that needs to be implemented. I'm sure other speakers are going to kind of intervene and they're going to tell us. It's a very modern code. It's a code which has features like case management, Tarun. Case management was a concept which came into UK from the Wolf reforms and really helped in expediting trials. Our CPC mirrors the pre-Wolf reform system of the UK courts. Now, UK gave up that complete way of doing civil litigation and adopted modern methods of disposal of cases. We have now also done that to a large extent by bringing in various changes to the Commercial Courts Act. But I think the problem that we all will face, and I'm sure other speakers are going to tell us, is that whatever we do, whether we bring in the concept of case management, whether we bring in the concept where we give most powers to a court to come out with a summary judgment under the Commercial Courts Act or the Commercial Court Framework, the question is not there. The question is, do we have the judges who can decide these commercial disputes? Do we have judges who can do a trial quickly, who can hear the matter? The court says that 6 months after the case management hearing, the arguments should be heard and orders should be reserved. But do we have that judicial infrastructure to ensure that that kind of a provision can be implemented? So the code is very modern. The code can take us to the $10 trillion economy. Of course, there will be changes as we go forward, and every code has its deficiencies. It's a good code, but I think there are no judges to implement this code.
Okay. It's a very important point made that there are no judges to implement this code. The code is good now. Udit Gupta, you run a law firm. Now, from the law firm's point of view, before we go to the judge's point of view, who are on the other end of the spectrum, if you could share with me, what are the fears that you feel from the client's end when you're, say, certainly servicing a client and the case delays? Uh, of course, there is this risk that, as Mr. Bhandari pointed out, that the company itself goes bankrupt because, if you don't recover your money, then your working capital gets stuck. If you could share with me the worry from in a sense, the client's end in that case, which is one of the companies.
So, see, what happens is it's usually what are commercial disputes? Why was this act enacted? The idea in 2009 was discussed in the parliament that it should be for the high value litigation. But that time there was an opposition that you're making 5-star courts now only for the rich who can afford courts. The idea is that if disputes are resolved, only the investor has a security that when he brings in the money, he will be able to even take it out. Right? Today in India, you get an arbitration award, but to get it executed becomes an issue. And it can only be executed under the Commercial Courts Act. The execution is filed there under an OMP in Delhi, as we see. In execution, to get a notice issued and served upon the other side becomes tough unless the assets can be attached. So that's the biggest fear that the investors have, or even the clients have, in case even when they have an award. Now, in fact, in 2018, there was an amendment that brought down the pecuniary jurisdiction of this act from 1 crore, which itself is low for a foreign investor, to 3 lakhs. Now, when we have a 3 lakh jurisdiction, there are n number of cases piling up here. The existing courts were made commercial courts. Hence, there's a lot of delay there because when they are handling these disputes, as Abhimanyu rightly pointed out, that there are less judges there. And in fact, Section 17 of the Act provides a very good thing that the high courts are supposed to upload the data of the pending cases. But there was a report by Vidhi which says that only 8 high courts have done it so far, and Delhi is the only high court in the entire country who has been consistently maintaining this data. Now, one good thing from the Act is that there is Section 12A, which provides for institutional mediation. Section 12A specifically gives the parties to first go for mediation in any dispute, mandatory mediation. And if the dispute is not resolved in mediation, then you go for the litigation. Most of the cases, the Vidhi has given a good data there that many disputes have been resolved with mediation, with the help of mediation, because both parties know the truth now where it's going to land. So they enter into a settlement. And sometimes the person who has to take the money also settles because he knows if I go in litigation, it will take me 3 years. I will lose on interest and my company can go in IBC. I might as well take a cut and settle here. So see, the investors today, the foreign investors, when they get these kind of fears, they don't like to litigate. They're willing to take a haircut and blacklist the employer, the person with whom they're working, who's not giving them the money. Hence, they choose not to work. And that sends a word in the market that India is not an investment-friendly country. So I think those are the fears that the investors have with respect to recovery money.
Thanks for sharing that. You will go to Justice Endlaw at this point. So now a couple of pertinent points raised by both Mr. Bhandari and Mr. Gupta. While addressing those points, I would also like to know from you that many often we hear bureaucrats as well as investors saying that India enforcement of contracts is a very difficult activity. You cannot get the contracts enforced. And the fear is that companies who don't have deep pockets may go bankrupt. And that is why a lot of investors fear to put in money because they fear to litigate. Do you think that giving judiciary more financial allocation is also a solution to this issue, which will ensure more courts, more judges? Or the infrastructure itself has to give an overhaul which was never seen in the past 70 years? Because, mere tinkering around the edges with a few 100 crores here and there now won't solve this purpose. There needs to be a massive fund infusion. Just your inputs, even on the infrastructure fund, I would want.
Thank you, Mr. Nangia. See, if I may just go back to the first question which you posed about what investor, a foreign investor, looks for in the dispute resolution in a jurisdiction of his choice or where he is intending to invest. It's not only a foreign investor, even domestic men of commerce are quite concerned about expeditious dispute resolution. That is why the concept of arbitration had begun, because it was envisaged that arbitration will be more expeditious. But somehow we still have a need for the courts, because there are a lot of disputes which can't go for arbitration, which have to necessarily come before the court. Now, the two things which any man of commerce looks for in a dispute resolution system are reliability and independence of the judicial system and expediency. To the credit of the Indian judicial system, I don't think anybody has raised a doubt about reliability and independence of the judicial system. At least it has not come to my notice that any writing to that effect that the Indian judicial system is not fair or anything. The complaint which has been plaguing us for centuries is about expediency, that we are rather infamous for the delays in dispute resolution, and which results in the investor losing out on his investment, or by the time the resolution happens, it's really not worth fighting. The issue has become stale. Now, this also, it's not as if commercial disputes have not occupied a special place in dispute resolution. If we see earlier, when the scales of commerce were not as huge as you are mentioning, we used to have a Small Causes Courts Act, which courts used to deal with basically commercial disputes of recovery of monies. That times, commerce was largely about money getting stuck up for goods sold or supplied. So those courts were meant for that. So they had a special provision that which said that all the procedure which is applicable to an ordinary suit under the Civil Procedure Code will not apply. So a lot of provisions were exempted, and it was supposed to be a summary decision. Similarly, when the Civil Procedure Code was enacted, there was an Order 37 inserted, which was again meant for resolution of commercial disputes, and which provided for the very same thing which Abhimanyu mentioned, that about summary disposal of such cases. Unfortunately, the judicial interpretation of Order 37, which came in 1976 and which held the fray till, I think, 2016, when it was ultimately set aside and held, that on the date of pronouncement in 1976, it was not good law because the pronouncement related to the pre-amendment time. So that's another very interesting aspect of Order 37. It took so many years for it to be said that that judgment is wrong. So Order 37 nullified that commercial procedure, and if that judgment had not been there and Order 37 had served the purpose, probably we may not have felt the need for the Commercial Courts Act. Now, coming to what you said, the comments about what Mr. Bhandari said about shortage of judges. Yes, shortage of judges has been an issue, but let me tell you another very interesting aspect of it, that it's not only shortage. I mentioned about the Small Causes Court. There was another concept in Delhi earlier, in the district judiciary. There used to be a commercial sub-judge or a commercial civil judge appointed. Now, all the commercial matters, whether they fall under the summary procedure of Order 37 or not, they used to be marked to that court. Now, at that time, I'm talking of the time I joined the profession, the High Court, which basically does the postings of the district judicial officers, they used to be very choosy in picking up a commercial sub-judge. They used to, if I may use that term, that term was not considered bad. Today, it may be considered bad. Generally, we found a Bania judge manning that court because they were supposed to be very wise. They could read the Bahikatas, the books immediately. everybody may not be very savvy with reading those books. So they chose such a person, and I have appeared before those courts, and they had a very distinct way of dealing with a case because they understood that, all right, how does a trade happen? Generally, a judge whose family was involved in business, so he would be hearing it on a dining table conversation, that how the trade happens, how the money is, you can find out whether the money is due or not. And the judges always found very innovative ways to, rather than go into the long procedure of pleadings, arrive at a decision immediately. And so it's not only about shortage, it's about selection. What has happened that the post of a commercial judge has become a district judge level post. I'm talking in the context of Delhi. I assume it may be the same in the rest of the country. So that post is allocated by seniority, not by selection. Ideally, it should be a post by selection like it used to happen earlier, that you have to choose who is savvy with these disputes. Everybody may not be good at everything. There are some judges who may be good on other aspects, so you may appoint them. The other thing which Udit mentioned is that the definition of a commercial dispute has become very, very wide, with the result that everything under the umbrella is falling over there, and which results in defeating the very purpose. The idea was to create a special court which deals with lesser number of cases and has more time to devote and decide fast. So if a court entertaining ordinary suits has 2,000 cases on its roster, the commercial court should have 1,000 or less cases. But it has acted other way around. The commercial courts have a heavier roster than the ordinary courts. So these are the 2 or 3 things which come. But otherwise, I think we have infrastructure, largely, I would say. And what needs to be done is application. Our judicial system has been steeped in that justice should be done. So that's why we have nearly a 3-tiered appellate provision. But a lot of times what happens is that in doing that procedural formality, that the right of appeal, right of hearing at every stage, we lose out on expediency. So there has to be a common thread running throughout.
That's a very relevant point. On this note, we'll take a short break and we go to Mr. Abhimanyu Bhandari on the other side of the break. Welcome back. Just before the break, we had Justice Endlaw making some profound comments on this whole issue. I'll go to Mr. Bhandari, and before you come in, I would also like to ask you 2 things. India will see an infusion of $1,500 billion in the infrastructure sector. This I'm asking you because you said that about NHAI contracts and payments not coming and that becoming a big issue. Do you think India does not even know the kind of caseload that it is going to face on account of such investment? Because if that kind of money, and that money is coming in India, India is the only country where that money can come. It's the last market left, in a sense, to commercialize. In that sense, infrastructure is yet not built here to that degree. So this money is coming. Do you think we don't know that what is going to hit us? Secondly, there is a bit of good news with Justice Ramanna speeding up the appointments. Our Chief Justice of India this time has done, in a sense, I mean, we had completely stopped, in a sense, appointing judges. And now at least it seems that has started happening. So that is one bit of good news there. Mr. Bhandari, from your end now.
So I'll take your last point first, Tarun. I think that we all are very pleased and to see that, judges are now being appointed and things are really moving quickly. So I think big kudos to the present Chief Justice of India, because I think across the bar, suddenly all the lawyers feel that things are moving and we are getting more and more judges. I hope this trend continues and accelerates as time progresses. Now, coming to your first point on the investment that is going to come into India. If this kind of investment we are looking that India is going to receive then India really needs to ramp up its judicial infrastructure. And when I mean judicial infrastructure, I don't only mean the court system. I also mean our whole arbitration system that we are trying to promote. Of course, we've seen the new Hyderabad Arbitration Center, which is the Telangana Arbitration Center, which is doing extremely well or has just started. We need more such centers all around the country. But, coming back to my first question, if you, and this is really the major contracts, if you're going to have big oil and gas companies, big infrastructure companies investing billions of dollars in our country, they would want a world-class commercial court. And as Justice Enlaw rightly said, that there has never been a question about reliability of our judgments. I think everybody across the board considers that the common law system is so well ingrained in our judicial minds that we get good quality judgments. The only question is, do we have enough judges to give those judgments? And we need to now ensure that certain judges are appointed who can continuously dedicate their full time in resolving commercial disputes. Now, I want to say something a little different, which I think not many people have said, or I don't think so, it may not be taken very well by many people. I think that a good $10 trillion economy should not shy away from making those people who want big disputes to be resolved in a court to pay for that. In the sense that I think that we should have a system where if a court is giving, let's say, 10 days or 20 days in a month to ensure that the whole trial is completed after pleadings are complete, evidence is filed, then on big multi-million dollar disputes, a threshold could be happening, let's say, for example, 100 crore plus disputes, where we could make them from the very beginning say that, look, if you're going to use the commercial court system and you want a judge dedicated to you to resolve your dispute, then you better pay for it. And I think that that time has come to do that. And I think that, we are seeing that happening in world-class economies. We are seeing very, very good ad hoc courts coming up in Dubai, in Singapore, where retired judges, not only from their country, but from other common law background countries, are joining and are providing speedy justice. So I think we need to come out, we need to kind of start thinking on those terms. Because I think if we can provide something like that, it'll be a win-win situation for everyone.
I'll take your last point, Mr. Abhimanyu Bhandari. You made a good point on ad hoc courts by saying that, of course, a fee should be charged if the disputes are 100 crore and above, where parties can pay for speedier resolution. Mr. Udit Gupta, if you could share this with me, do you also agree with Mr. Bhandari's idea of ad hoc courts? Do you think retired judges can be engaged on an ad hoc basis for 4 or 5 years to ensure that commercial disputes are disposed of quickly?
I think that's a very good idea that Abhimanyu has made. In fact, our constitution also provides that once the judges retire, the Supreme Court judges, they can again be appointed. But only the difficulty is they don't prefer to be appointed because their judgments can be set aside by their juniors. Now, that's a very big thing. So I think they will face an issue. But nevertheless, it's a step that we must take, the ad hoc courts. Like for the international judges being appointed, Justice Sikri, A.K. Sikri has been appointed in the Singapore commercial courts, right? So that way, it will be a good idea to have those foreign judges coming in because they understand how their country works. They will be able to give us good ideas. And taking a cue from what Justice Enlaw said, I would say that we can have training of judges. See, to find specialized judges in commercial courts may be a tough idea. So we can have specialized trainings for them where it can be a week-long training for the judges. And having small batches of them, training is very important. For the procedural formality, also what Justice Enlaw said, in fact, in 2021, Justice Gautam Patel of Bombay High Court, he did a fabulous thing. I think there's a lot to learn from him. What he did is there were 200 cases where the summons were issued, court had issued notice, but the lawyers or the litigants had not deposited the process fee by which the summons can be sent to the defendant. He clubbed all those 210 cases together and in 15 minutes took steps to sort it out. Now, we need these kind of innovative steps also that the courts should take. See, this is very, very important that we come out with these innovations to sort out the issues. Infrastructure, I think we are building quite well now in the courts, and virtual hearings have to be mandatory. You can't make it now कि आप physically खोल रहे हैं, so we are doing away with the virtual hearings. You have to have hybrid model. That's the need of the hour.
That's a good point, mate. I'll go to Justice Enlaw at this point. Now, you heard both the panelists. I would also want to add a few points here. Now, as far as appointment of ad hoc judges is concerned, of course, your view on this point. Second, the hybrid system is a good point that Mr. Gupta raised. Do you think it's doable to continue it? On both these points, would also want your answer, actually.
See, on the appointment of ad hoc judges, we have a judgment from the Supreme Court now, which has held that it is a provision which is meant over and above the strength. So you can't appoint ad hoc judges when you are not filling up the strength itself. So we are all bound by it. And in fact, on your show only, I had expressed the view that it's not as if there is dearth of talent, that we need to go to the retired judges. We have plenty of talent. It's just that there are some delays in appointment. I can speak confidently about Delhi. In Delhi, the strength of the High Court is sufficient. We don't need more than that. But provided all 60 judges are in place. Unfortunately, today also we are functioning with 36 judges. So that is as far as ad hoc is concerned. One little clarification from the bench point of view, which I have had the experience of about what Udit said about hesitation because the judgments may be set aside. See, that a judgment is a view of a judge. There is nothing personal about it, or there is no affront about my judgment being set aside. The lawyers and the judges are called best husbands because they are used to being overruled. Nothing about that. And I'm sorry, you asked for another one thing. I think I missed out. Yeah, about the process fee, what Udit mentioned. In Delhi, we have innovated on that. We have made a provision for one-time process fee. So that thing of every time depositing the process fee, that is no longer required. When you file a suit or you file your defense, you deposit lump sum amount. Without that, it is not accepted. And then that takes care for the entire life of the suit.
So I have one question to ask you.
Yes.
Arbitration, if there is an arbitration involving the qualities of rice, then you have got special assistants, technical experts, if I may call, who will come and sniff the rice and can tell which variety it is.
Yes.
So which got nomenclatured as sniff and tell arbitration.
Yes.
So this expertise the arbitrators are taking. You think the courts, because not all judges come from a business background in that sense, have studied business. Do you think time has come that, you should have amicus appointed in many matters so that, they can assist the court in arriving at a quicker resolution? You think, is that possible? Chartered accountants or even lawyers who have, decent knowledge of commerce. Is that possible that in many cases this can happen?
It is definitely possible. The only thing is we do not have good panel of experts. See, it should not be left to individual judges to pick up his acquaintance as an expert. There has to be a panel, and there has to be what we have done under the insolvency and bankruptcy code now. Something like that there should be an examination, or there should be a selection of people on the panel. There should be a grading of them about their neutrality, about their report being accepted in how many cases, and they can be removed from the panel if it is found that. So that is the issue which we are, in fact, this problem is arising a lot in patent disputes. Patent disputes, unfortunately, we don't have a panel now. Under the rules, which hopefully will be spread across the country, Delhi High Court has framed the IP division rules. Under that, we have made a provision. A provision has been made for selection of experts, particularly on patent, who can advise the judges or give an opinion, and which opinion then can be evaluated by the judge. So all this is provided under the Commercial Courts Act. We need to put the systems in place.
Okay.
Training also, what Udit mentioned, that is also, there is a provision for that under the Commercial Courts Act.
Training also. Mr. Bhandari, now complex disputes involving the power sector, the coal sector, mining sector. But judges have been burdened with such cases. They are way too complex even for professionals. Do you think that to do quicker dispute resolution in face of such complex matters also gets to be a problem? Because it is difficult. I mean, it is not easy because not every judge is an engineer, not every judge is a geologist, a mining expert. It is indeed something that we have to find a solution to. Do you think this problem the Chief Justice of India needs to address? It should be thought at the highest levels of the judiciary.
Okay. Tarun, I have a very different view in this whole matter. I feel that those who've been trained in law and who have the experience to adjudicate should adjudicate. If they need technical resource or they need technical help, then the procedure and the framework should provide, like Justice Endlaw has said, a panel of experts. So if a judge has to apply principles of common law, has to apply principles of Indian Contract Act in deciding a matter, he's the best person who can decide that. But if he feels that he needs an expert to tell him whether really the price of that rice on that particular day, the day the breach occurred, was $20 or was $25, and he needed an expert to come and give him that market view to him, then he should be able to pick up an expert or pick up two experts and get them to give a report. And then what is called a battle of experts can happen in court. And the common law judge can hear both those experts and then come to a conclusion what he needs to do. But we can't leave the process of adjudication, applying principles of law to a dispute, to decide that to a technical person. No, because the rule of law, Tarun, one of the biggest exports of rule of law is UK. And they've done it, I think, quite well. They've got this huge plethora of experts who come in. Parties also know which are good experts to appoint. And often, more than often, there are battle of experts in a courtroom. But they leave it to the judge at the end of the day to adjudicate. Because, at the end of the day, if you want a good quality judgment and you want a good adjudicating process, you can't leave it to technical members. You need a law member. You need someone who has the experience to look at the documents, look at the pleadings from a legal perspective and give a judgment to parties.
Thanks so much for that input. We're almost out of time. Mr. Udit Gupta, one small input before we end.
I think on the technical part, like for the power disputes, we have the electricity commissions and the appellate tribunal of electricity. But again, the pendency there is huge now. I mean, till 2015, I think there was no pendency. Every dispute and after was decided in a year. But post that, today when we see the chairman is not there, the technical members aren't available, not appointed. So that's one thing I say, that we have set up specialized tribunals as well, but they are also not functioning well. Today, there are 33 vacancies in NCLT and there are 750 applications. So as Justice Endlaw said, that there's no dearth of talent. Top bureaucrats, top judges are applying for those positions. But see, 750 applications to interview, shortlist and just select 33. It's a huge, there's a committee of 5 people. So I think these have to be, delegated further.
Thanks. Today was a good show. Justice Endlaw, Advocate Abhimanyu Bhandari, Udit Gupta, Managing Partner, Udit Kishan and Associates. A good set of points have come. I see only a ray of hope when I see Chief Justice of India, Justice Ramana, expediting appointments. We finally are seeing judges being appointed. But I think there is so much to be done. And in an economy which is seeing billions of dollars being poured in every year. And one thing which I wish to also take up in the next show is that, many times contractors are looking at litigating even while servicing the contract. While the execution of a road construction is going on, there are many disputes that occur. So that should be decided even while the execution is happening. But if that small dispute is not decided, then it snowballs into something bigger and the whole contract goes out of the window. That we must look after, because the industry is asking for that. That, we want to keep on making the road, we want to keep on making the infrastructure and keep on litigating along wherever we are disagreeing. That we will take up. But thank you so much, Justice Endlaw, for sparing your time. Abhimanyu Bhandari, Udit Gupta, Managing Partner, Udit Kishan and Associates. It was a good discussion and good inputs. Thank you so much, viewers. Thank you.
Thank you.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.